news. This is how Young Thug will beat his trial. Pay attention and listen up. He's on trial for a RICO charge. The prosecution, Miss Love, don't even know the elements of a RICO trial. Elements is considered as ingredients that need to be proven in order to find someone guilty of violating a said statute. I know I sound like a lawyer, but just sit back and let me ride. All right. All right, you know what it is. Unique Mecca Audio, man. If you subscribe, hit the notification bell. If you not subscribed, subscribe and hit the notification bell. And I want to take this time to thank y'all for me getting my 100,000, subscriber plaque. I'm going to take this time to thank y'all. I'm going to break down what an overt act is and how the government is going to come back and the feds. This is how the feds are going to come back, right? This is how they're going to come back, and they're going to give them a RICO indictment in the Federal Department of Justice for violating the RICO laws, right? I'm going to break all that down to you. I'm talking about Woody, Monk, Tunk, and other names that wasn't as, highlighted as they were. But they're going to bring back federal indictment on all of them. You know what I mean? This is what it is. So whatever y'all own, this is where when you're on the street, you start to liquidate, meaning you get rid of what you got. Not telling you what to do, but that's what we did as drug dealers back in the days. You know what I mean? Now, I'm going to play this video, and you're going to see where Miss Love is going to open up what they call a Pandora's box when she asks about trying not to have to list all 191 overt acts in the verdict sheet. Now, that's not what Brian Steele is asking. Brian Steele is asking if, that they have to at least find one overt act within the statute of limitation in order to find them guilty of the RICO. That's all Brian Steele is asking about. The jury have to find one overt act within the last 5 years, not all these other overt acts that go before that. Sit back and let me ride, man. All right.
Okay, so Mr. Steele had brought a challenge to, and I may be misstating this, but I think to including, for the jury's consideration, I guess, overt acts that occurred prior in time to the RICO statute. Is that right? Or is it not? It could be not right.
I think it's right.
Okay.
For verdict. So the example that, the obvious example that I use in my mind is there's 191 overt acts.
Right.
And let's say overt act, the rental of the Infinity happens on January 7th of 2015. That's the only overt act that's proven. Every other 190 are not proven. There would not be a conspiracy because the overt act is not within 5 years. So my point is, I understand that the conspiracy allegedly continues and the state of Georgia can put in, if the court permits, different examples of predicate acts and overt acts.
And do you agree that they can put in for consideration overt acts that occurred further back in time than the 5 years?
Yes, the case law says that that's appropriate.
Is your argument just that unless at least one of the overt acts that the jury finds, I'm going to have to start over because I can't.
See, right here, they all confused down here in Georgia, including Judge Whitaker, because they're not used to a RICO trial. I sat there on trial just like Young Thug, having to deal with this, and this has been my argument for 20-something years, so this is a pleasure to break this down. What Brian Steele is saying is that they could use overt acts that go before the length of the conspiracy, is what he's agreeing to, right? But they have to agree that at least one of the overt acts happened within the last 5 years, because that's the statute of limitation. But see, overt acts is just used to show the bad conduct and the furtherance of the conspiracy. That's all it's used for. It's not for a conviction. So that's why I said, like Little Woody, Monk Tonk, all of these dudes that testified. First of all, Miss Love gonna put them all in jail. That's Miss Love's goal right now, because they didn't play her ball. You know what I mean? But they could use everything that they testified to and make them overt acts in a federal indictment, which will be coming. That's why they're not calling a mistrial. They know that this is a mistrial. They're not calling a mistrial because they know that they're getting all of this evidence, and the feds is sitting in there right now as we speak, taking notes on these overt acts and predicate acts. Predicate acts are what you're charged with in the indictment that they could use, that the jury must unanimously agree, that you committed. Those are predicates. Those are charges in the indictment. But now overt acts is just shows bad conduct that happened over the course of the conspiracy. Y'all understanding where I'm going at with this? Okay, so now all they're talking about is the time frame, but watch how Miss Love screw up the whole thing, and that's why I know that Young Thug right now got a chance at beating it. You know what I mean? When the verdict comes back. Check this out. I'm going to break that down too in a minute. But they're going to use everything these young men is testifying about in a federal indictment. So the feds is letting this trial go on, even though they know it should have been a mistrial 20 mistrial motions ago, right? But they just getting information by letting them talk on the stand, feeling that they can't be charged in the future in the state. Now, even in the feds, like Little Woody, they can't charge Woody with those in the feds from what they said at the thing, during the course of the trial, but his plea agreement did not say that it excluded the feds. But they did say it on the record, so he has an argument. Now, let's play this.
Can't remember how I started that.
See, they don't even know what she's talking about.
Unless at least one of them is within that 5-year statute, then they can't be convicted. That's your argument. Yeah.
Perfect.
I mean, I think y'all agree with that.
You heard that?
That it didn't sound like that isn't what I understood your argument to be before, but if that's what your argument is, then yes, I agree. That appears to be the law.
See, and this is where Miss Love don't want to take well enough alone. Look how she opens up this Pandora's box. Man.
So is he?
Look, listen to her.
So I'm not hearing that he's asking that 190, that there's a form for that includes 190 overt acts on the verdict form, because, and this is the reason I'm asking about that, because any relevant information or evidence that is permitted at trial,
Right.
that constitutes an overt act. The overt act does not have to be alleged on the indictment, and we certainly don't. That list that is contained within count 1 has never been represented as an exhaustive list of overt acts.
See, right there, she's wrong. She's dead wrong. Listen to what she's saying so y'all could understand this in layman's terms with me. She's saying that they have 191 overt acts that, Young Thug and his co-defendants is being charged with. And she's saying that they shouldn't have to list 191 on the verdict sheet. There's going to be like 10 verdict sheets listing all of them. But you do, Miss Love. That's the law. That's what you get paid the big money to do, to bring down the RICO influence racketeering organization. Oh, corrupt organization. All right, now. She's saying that they don't all have to be, they have to be listed because even though there's no, verdict on an overt act, only on a predicate act. A predicate act is what you're charged with. Now, an overt act, like I said, shows the course of the conspiracy and what you did to further it. So she's saying that, listen how crazy she gets with this, right? It make no sense. It's like, but right here, I know even if they find him guilty on appeal, this is where he'll win. Per Richardson versus United States came out June 1st, 1999, where they quoted me, United States versus Hall, saying that the Fourth Circuit was wrong, that the jury have to be unanimous and specific as to exactly which overt act they're choosing. That's what it is. They got to be unanimous. Unanimous means all 12 have to agree on the same ones. So now you got 191 overt acts and you got 12 jurors. So y'all understand how I'm saying he gonna beat this. Now, all 12 jurors have to agree on the exact same 3 overt acts out of 191. So if 11 jurors agree to all of the same 3 overt acts, and in the feds and the RICO it's only 2. So if 11 jurors agree to 2 overt acts, right? That's specific. I mean, they specifically said that he committed overt act 1 and 191. You know what I mean? If 12 jurors say that and 1 jury did not say that he committed overt act 1 or 191 and they pick number 2 and 189, then that's not a RICO conviction, because the elements, which is ingredients, you know how you bake a cake, you need egg, flour, and milk. You can't take out, the egg and just make the cake with flour and milk, or you can't take out, the milk and just make the cake with flour, milk, and water and say you have a cake. Yes, it may look like a cake, taste like a cake, but it's not a cake because the ingredients call for egg, flour, and milk. Just like the elements, like I said, is the same as a recipe. Now, the elements, which is the recipe for RICO conviction, is that all 12 jurors have to agree to the same 2 or more overt acts, and they have to be specific. They even have to pick, the same 2 predicate acts. You know what I mean? But this is for each individual. She's going so far off pitch to show you how they don't know nothing about a RICO, because obviously, y'all look it up. Somebody look it up and let me know. Y'all, what's that? Paralegal Institute of Washington, D.C. I watch y'all stuff when I use a lot of your content. And right now, this is from Megam Conniff, right? Y'all look this up, and I'm telling you what I know. You know what I mean? I went to the ultimate law school for 26 years of my life in the prison law library, from Lewisburg to Allenwood to ADX Supermax to Lombard, California to Coleman, Florida to Lee County, Virginia to Atwater, California to Victorville. These are my institutions that I studied law in. And that's why I'm sitting here talking to you, letting you know that Miss Love is all screwed up with her terminology. Now, let me play this a little further. I don't want to confuse y'all.
And the overt acts that we introduce at trial don't have to be included in count 1. And if the jury finds, I mean, I understand what Mr. Steele is saying, and I'm not arguing with that last summation that the court gave. But my point is that I understood him to be saying something akin to, I want a special verdict form that includes the overt acts that are listed on the indictment, and I want them to say if they found this one, this one, this one, and if the ones that they find occurred prior to 5 years before the indictment, then they cannot find the defendant guilty of that count 1.
That's because they have to be within the statute of limitation. That's all he was talking about with the statute of limitation. And this lady opened up Pandora's box, where when you open it up, you don't know what you might find. You might find a rattlesnake. You might find a pot of gold when you open the box. That's why they call it Pandora's box. Now, she's sitting here, done switched it from Brian Steele saying that what at least one of the overt acts would have to be within the 5 years of the course of the conspiracy, because they went back to overt acts all the way back to 2014, 15, as you see they were testifying to. So the jury hear all these different things that happened from 2015 for over a year, going on 2 years. And then now you want them to decide which ingredients out of those 191 overt acts that was spoken could be used in the recipe for RICO conviction. Impossible. You know what I mean? So that's why I know what time it is. Y'all pay attention. If I'm losing y'all, rewind this and look this up. And right now, I'm challenging any legal scholar. All of y'all doing this YouTube, I'm challenging you to go against anything I'm saying in this video, because y'all are putting out false propaganda, just showing these videos and not breaking it down to the viewers so they understand. And that's why I got my little measly 100,000 subscriber plaque. You know what I mean? Thank y'all again, and round of applause to y'all. Round of applause to y'all for that. Round of applause. Round of applause. All right, relax. Let me get back to this Miss Love and Brian Steele thing. So that's what's going on here. Now, Miss Love even went a step further and said that the overt acts don't have to be in the indictment. No, you can't get found guilty of anything that a jury of your peer did not bring back on an indictment. That falls under Apprendi versus United States, also came out in June 1999. Look up Apprendi, Paralegal Institute, Megum, Cuff, and what's that, Crime and Law, Law and Crime, whatever it is, because y'all just showing these videos, not breaking it down. You can't do that, Miss Love. You sound like a bat out of hell with everything you're saying right now. Even the judge gonna tell you, I'm not gonna make a ruling on that now, but she's gonna have to make a ruling on this, and she knows a little bit of what she's talking about, but she still don't get it. But she's gonna go back and look at the case law, and I just gave y'all case law. Richardson versus United States, with the two brothers that was GD brothers, gangster disciples out of Chicago. They was hustling. They had all type of stuff go on, and they took it to the Supreme Court because the prosecutor used United States versus Unique me to deny the Richardson brothers. So when they went to the Supreme Court, they was using United States versus Theodore Edmonds. Big round of applause to Theodore Edmonds, official dude out of California. I had the pleasure of being locked up with Big Ted too, man. Big round of applause to Big Ted, man. Big round of applause. So the government was using United States versus Hall to deny the Richardsons, and Richardson was using Edmonds. When the Supreme Court heard it, they had to let it be known that it was a split between the Fourth Circuit that United States versus Hall is in, and the Third Circuit where United States versus Edmonds is in. And even, right, Rayful Edmonds raised this charge. Both of these cases, and see, I know this off the top of my head because I had to fight this for all these years. Rayful Edmonds and Theodore Edmonds' case is in 52 F3D. Y'all go look that up. 52 F3D, you can start with one of the cases at page 1080. Rayful Edmonds raised the same thing, and they even put in the Rayful Edmonds case that the jury had to be unanimous and specific about which three overt acts constitute the continual criminal enterprise, which is kissing cousins to the RICO. Continual criminal enterprise is saying that you continually violated Title 21 of subchapter 2, you know what I mean, of Title 21, by selling drugs with a continuing series. So they had to decide what was a series. Was it 2 or more violations or 3 or more violations? We know when they have a basketball game, football game, whatever, when they have a series of games, it's at least 3 games, and it's the best 2 out of 1, 2 out of 3. It's not the best 2 games and 1 and 1, because that's just a straight up joint. So that's where we at if y'all paying attention. But look how they break this down. And I know Judge Whitaker gonna go back and look at this. So y'all tell all these paralegal dudes, y'all share this video with them and tell them Unique Mecca Audio said that they must be unanimous and specific about which 3 violations. They put it in Rayford Edmonds' case in 52 F3D, and they put it in Theodore Edmonds' case also, not related. Rayful is from DC, Theodore is from West Coast, California, Unique was from Virginia. That made it a split in the circuit. All right, let's ride. All right.
Only the ones they find occurred more than 5 years prior.
Right. That's
Then
what
they
I
can't
understood
find
him to
them
be
guilty.
saying. Yes. So
We're all on the same page then.
So as long as we're not talking about listing out
See,
the
she's screwing up
191,
now.
Oh,
because
we might be talking about listing out the 191, because how can I know whether they found one within the statute unless they say yes or no as to each of them?
Right there is the judge is bad. I like Judge Whitaker. You know what I mean? Because she's just learning. But she knows common sense. Common sense, you saying that you're going to listen, that there's 191 violations that's in the indictment is what Ms. Love is saying. Then Ms. Love is also saying that you can use anything that was testified to at the trial, even if it wasn't in the overt act. So we could create overt acts just from testimony of bad conduct that was said, even though there's no grand jury, indictment returned on these acts that's mentioned that's going to be used as overt acts. No, you have to list the 191 overt acts on the sheet, just like this, right? Just like this. You got to list the 191 overt acts, right? And then next to it, you got to put yes or no, meaning did he commit it or not. But the verdict sheet for the for the violations, you know what I mean? For the substantive counts, right? They'll have next to it guilty or not guilty for the substantive acts. That's where they have to get a guilty verdict in order to find you, guilty of the charge. But with an overt act, they just have to put yes or no, meaning you committed it or you didn't, because there's no penalty or sanction for an overt act. But an overt act triggers, the enhancement of a conviction, because you need that in the ingredients to bake the cake, which is to get the indictment with the elements. Y'all follow me? All right, let's go. Now, you heard what she said last, so y'all, I don't talk my way out of this. Y'all don't understand. Now, Judge Whitaker just clearly said, oh, no, you might have to list those 191 overt acts. Brian Steele never brought this up. This is where this lady is so overzealous and thinking she cut like that she's bringing up a stupid argument that's going to wind up getting this young man acquitted. Listen to them how they're going at it now about these 191 overt acts have to be listed in the indictment. You know what I mean? Listed on the verdict sheet. Because if you don't list them, how is she going to know what overt acts out the 191 they felt they committed? And then if it's not in the indictment, how you're going to call it an overt act, and where would the yes or no go for the overt act that wasn't an indictment that was mentioned at the trial that you're converting into an overt act? No, you can't do that, Miss Love.
Well, they could state, they don't have to. The reason that I would object to putting 191 is that it would limit them to consideration of 191.
Yes, they have to decide only from the 191, Miss Love. Yo, Paralegal Institute of Washington, D.C., get at me, man, so that y'all can explain this to the people so they know what they're really watching. Because y'all just showing videos and they looking for the antics instead of learning the law to prevent getting caught up in the law by hopefully prevent them from hitting the street. Yes, you have to list the 191, Miss Love. How else is an appeal court, when he appeals it, God forbid if he's found guilty, gonna know which overt acts they chose, whether they fell within the 5-year statute of limitation that Brian Steele brought up, or whether they was even in the indictment. And you yourself is saying out your mouth they don't have to be in the indictment. That alone could get this case thrown out. If you bringing them to trial and expecting a conviction without it even being in the indictment coming back from the grand jury of his peer. That's what takes you to trial, Miss Love. You learned this in law school 101. Why do I even have to break this down to these lawyers? I understand why I'm breaking down to my subscribers, because thank God you didn't have to sit in jail for 26 years like me to learn this crap.
And if evidence of one that happened, for instance, during the course of this trial is not on the indictment.
It's not. And we haven't gotten to that, but I would think they can consider that potentially. But if the only thing they find is an overt act is something that occurred post indictment in the jail, and that's the only thing they find, they can't be convicted because you haven't indicted them for that.
See, that's exactly what I'm talking about. You see what you just said? In other words, all this stuff that they brought in, right? This where they screwed up. Because they think in a RICO trial, you could just throw everything under the rug. So they screwed up right here, right, Miss Love, because Miss Love brought in evidence about what happened in the jail while the trial was going on that they wasn't even indicted on. So now if the jury come back and say that they're guilty for, you know, the shank in the jail or the drugs in the jail or the drugs that was allegedly passed the young thug in the courtroom, they have to throw out the case. They have to throw out the case. So this is what the lawyer's breaking down. Said, oh no, it can't be post-indictment, meaning after the indictment, you know, the overt acts, and they can't be before the 5-year statute of limitation. Now, pay attention. All right, we roll.
Your Honor, yes, you can, and I will get that case law for the court.
Okay, well,
but
I'll
definitely
be
you can.
interested in seeing how they can get convicted of something they weren't indicted for, but okay.
You see that? How are you going to get convicted for something they wasn't indicted for? Yo, somebody contact Brian Steele and the rest of these lawyers and tell them to go get Richardson versus United States 52, Richardson versus United States, June 1st, 1999. Richardson versus United States. That's Eddie Richardson versus United States, June 1st, 1999. Tell Brian Steele and the rest of these lawyers to go get that case to go back at this crap that she's sitting here saying. Because they never dealt with a RICO, so they don't understand this. I had to live with it for almost 3 decades. And everything she's saying, they must throw out the indictment if they get found guilty for any of that. Let's go. Listen to this.
I have so much exciting case law to look forward to.
Yes, Your Honor, the court does. They were indicted for
See, she got so much exciting case law, like Richardson versus United States. Mark my words that Unique Mecca Audio told you that you're going to hear that case mentioned when it's time to bring this up, when it's time for them to do the verdict sheet. Because they must be listed on the indictment. The jury must be specific and unanimous. And they can't list, and for real, they can't list anything that goes out the statute of limitation. Now,
conspiracy to commit, to violate the Georgia Racketeer Influenced and Corrupt Organizations Act. The overt act, that's count 1. The overt acts that are listed in the indictment it's
So, okay, they were indicted for conspiracy and
for
A and B?
No, they were indicted for conspiracy.
Okay.
all right, let me explain that. They was indicted for conspiracy first, right? So they have to show that there was a conspiracy. That carries 10 to 20. Then they have to show that there was a RICO. You understand? Now, so they got the conspiracy. So a RICO is saying that they took it to the next step of a corrupt organization. Pay attention, y'all. Pay attention.
And so all the jury needs to find, after they find that there's an enterprise, that there's conspiracy, that people participated in it, only one person has to commit one overt act for the jury to find them guilty.
No. Only, listen, stop it. It's no. It's not no only one person have to know that each person get their own overt acts decided by the jury. Come on, Miss Love. How you gonna hold all these men responsible for what one person did? No. Each one have their own indictment with their own name that says the state of Georgia versus that one name. Not that state of Georgia versus all of these dudes and they being tried together and that. I don't know. That's just proceedings that happens after the fact. But each one has a right to be convicted by a jury of their peer. about violating each one of these statutes that you brought against these young men. So stop it, please. You sound crazy.
Of count one, and not by them, I mean all of the
Right.
people that they
As long as
determined
they
were
were
part of
all
the
in the
enterprise.
conspiracy.
Right. So if they find and believe that during the course of this trial, an act that is considered that can constitute an overt act was committed by either one of the defendants, then they have what the law requires to convict each of the defendants that they find participated in or conducted this conspiracy guilty of count.
No. Gunshots. If the jury find one individual committed an overt act that constitute violating the racketeering influence corrupt organization, then that goes to that one sole individual. It doesn't overlap as a blanket over the rest. Stop it. Please, somebody. I'm begging you. Challenge me on this so the people and the viewers would know what the law is and know that this is a dirty game where you got the judge, the prosecutor, the lawyers, nobody even know the law on what they're trying to take this man's liberty and life for. Stop it, man. Where do they get this stuff?
Count one. So the notion that you enumerate 1 through
Yes.
1 through 191 overt acts, and that you limit the jury's consideration to whether or not the overt act that they find the one person committed is within these 191 acts is not an accurate statement.
All right, well,
of
give
the
me
law.
Yes, it is. Now she's going to ask for case law. The case law that Brian Steele need to get is Richardson versus United States. That was the first time they heard this issue in the United States because the RICO Racketeering Influence Corrupt Organization Act and the CCE, aka Continuing Criminal Enterprise, didn't come out until 1972. And they wasn't hearing these cases because these cases was built for like the drug lords, for the mafia figures, not for the gang members on the street corner or the little 20 selling 25 keys a day in Washington Heights that I got convicted of. I was a peon, considering the men that I met during the course of my 26 years that was convicted of bringing in tons into the United States. I was a peon. That blows you guys' mind. Oh, he said he sold 25 keys a day. Check my indictment. Stop it. Let me finish this up, man. The judge gave me ask, give me case law on this, because none of this makes sense. Even to a layman. A layman means someone that don't know the law.
the law on that. That really wasn't what I was trying to address anyway. What I was trying, but I mean,
she
obviously
opened
we're
a
going to have to
Pandora's
deal
box.
with that as well. What I was trying to figure out is whether Mr. Steele was arguing that if it was outside of the 5-year statute, those overt acts either couldn't be considered, which he's not arguing, or couldn't be found, which he's also not arguing. He's just arguing they can't be convicted unless at least one of them is within the statute, which we all agree
If
to.
that's all he's
Okay.
arguing, then I don't have
That's all he's arguing, but I'm going to
That's all he was arguing, Miss Love. You're the one that brought this crap up, Miss Love. You opened Pandora's box that's going to free Young Thug and his co-defendants. Because now you have to, listen, if Miss Love don't list 191 overt acts on an indictment, it's automatically a reversal. The 191 overt acts must be listed on the indictment with a yes or no next to each one so that each juror goes through determining if they committed the same ones or any of those. If you don't list them in the verdict sheet, how do you know what overt acts they use? Look at, I'm going to give you my case because I was the first one they screwed off with this. You look up United States versus Hall. 93 F3D, page 126 to 130. That's where my case is at for you rat bastards and that want to challenge this. All I'm trying to do is preventing the youth from going down the path I went down so they could see how strenuous and how this fight is dealing with these people when you break the law. Look up 93 F3D, page 126. My case go to 132, and you'll see everything that happened with me. So y'all go ahead and look it up, and you'll see who my rats are and everything, and you'll see everything they dealing with now with the rat going up there with the impeachment, the notes, you know what I mean, the testimony from best friends. I've been through it. Go look it up, 93 F3D. All right, you ain't got to go far. Let's go.
Need to know, because you're going to be arguing against that kind of a jury verdict,
The form.
and that they could find an overt act that occurred subsequent to the indictment and is therefore not contained within the indictment could form the sole basis for them being found guilty. And I'm going to need to know the law on that.
You see, she's admitting she don't know the law because Miss Love don't know what she's saying, but they're going to argue that when it's time to put the verdict sheet together. And there's no way in God's she would win that. No way would Miss Love win that. Because how do you know what the jury chose, man? Come on, Miss Love. The lawyer's smooth. She letting me know I don't know nothing about it. I never did a RICO trial, but I'm going to be interested to read the cases. You know what I mean? Let's go.
And to be clear, just to make sure that the court understands my position, not just that happened since the indictment. If there's an overt act that's not listed on the indictment that they find did occur, even if it happened pre-indictment,
Okay.
because we did not and do not have to include all of the overt acts committed in furtherance of this conspiracy.
Yes, you do, Miss Love. What are you, nuts? If you didn't bring the overt acts to the jury, how would the jury know what to bring back a grand jury indictment on? You had to present it to them, and the jury had to pick specifically, and in that indictment, each overt act should be listed, must be listed in that grand jury indictment. And that's how they put it. In other words, excuse me, not the grand jury thing. That's how they put it in the indictment. They grab the indictment from what was presented to the grand jury. So if these overt acts was not presented, Miss Love, like what happened in the courtroom with Thug allegedly, like what happened allegedly in the jail with this one getting stabbed, this one with knife, and this one with whatever, the grand jury didn't hear that. So that has nothing to do with the case. That alone is a reversal. And I'm telling you, get any legal scholar, get any, I don't care if he went to Harvard, to challenge what I'm saying. Because the law is the law. And the story. These YouTube dudes, they don't know what the heck is going on. They go up there and they just talk the talk, and they all over the place. But I'm telling you the facts of the law.
So that's the reason I would object to that.
You don't have to object to it. I'm not making a decision right now. I'm just.
See, that's what she said. She said she's not even making a decision right now. You know, so let's get this right? Let me get up out of this, because that's crazy. You know, that's crazy. You know, well, welcome to New York. Round of applause to New York. Round of applause to New York. We made it through September 11th. You know what I mean? We made it through September 11th with no incident. Welcome to New York. But now, let me explain to y'all. I don't want y'all hitting the streets. I don't want y'all winding up in these people's courtroom because they're not playing no games with y'all. None whatsoever. Look how they're trying to take this man's life for something that a jury of his peer didn't even hear. Where do they get this stuff from? Somebody please tell me. It makes no sense. All right? Now, let's take it, where we gonna go? All right, now we're gonna come back up here. Take it back to the courtroom. If you subscribed, hit the notification bell. If you not subscribed, subscribe and hit the notification bell, and cop the book A Roar in Harlem at aroarinharlem.com, and it's on Amazon and Bing and Google and all that other stuff. All right, and make sure you hit the like button. Let's get up out of here. All right.
Cheers to the crime, the crime, the crime, the crime, the crime.
Hey!
Heat back on the strip, getting back in the mix. What he mentions is a gift. You stand up 10 toes down, and I suggest you pay attention to this. Take a little gully posse and put it in home. Cut from the bar, came up from the bar. Drop the book, you should go and get it. An Instagram page and a YouTube, you can go and visit. Then you can consider yourself linked in. Sit front row and get juice from a kingpin. How he went through it, so you ain't gotta go do it. Did not pay attention, would be stupid. Talking about a man that probably put your grandfather on. Probably the reason that him and your gram got along. A man that generated millions on the block. Did his time, never swilling to the cops make an audio. In the 90s, drop top beamer so shiny. I let shorty go, she was whining. Treat her like my past, she behind me. Spinning a couple bands on the dapper Dan. You be back again, getting green like the Packers fan. No cap, this is a roaring uptown. Baby horn uptown, Dominican bust down. Now we on the positive, you ain't got a lot to give. Now you trying to stop the kids from being an operative. So take heed, homie, lend the air. He started in uptown, he gon' finish there.